Thanks for joining us for today's webinar, Facilitating Redress and Other Compensation Options for Victims and Survivors of Child Sexual Abuse. My name's Penny Sullivan. I'm part of the capacity building team at CLCQ. I'd firstly like to acknowledge the traditional owners of the land on which we are holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. I pay respect to their elders past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. I also pay respect to the traditional owners throughout the country and extend a warm welcome to any First Nations people listening today. So we're really pleased to welcome Rachel Neal and Ben Chapman from No More, who are going to discuss the operation of the National Redress Scheme and some important amendments that came into effect this year. They'll also discuss other options for survivors, including those abused outside of institutions. I'll ask Rachel and Ben to introduce themselves further when I hand over in a moment. Before I do that, just some quick housekeeping. Today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. The PowerPoints and other materials are available to download from our website and from the handout section of your GoToWebinar control panel. We do encourage you to ask questions. If you could type your question into the question box on the control panel and we'll read your question out at the end, but do please feel free to type them in as you think of them. So that's it from me for now. I'm going to hand over to the No More team and I'll talk to you again at the end of the session. Thanks so much, Rachel and Ben.
Thanks, Penny. Hi, everybody. Thank you for your time today. Ben and I would like to also acknowledge the traditional owners of the lands that we're meeting on today. We're also on Turrbal and Yagara country, and we want to acknowledge elders past and present and acknowledge that sovereignty was never ceded. Just got some housekeeping. This is required by our funders, some information about where we're funded, and then also want to give a content warning. So we will be referring to child sexual assault and child sexual abuse today. Some of it might be disturbing or upsetting, and we want you to look after yourself, encourage you to use your discretion as to whether you continue watching. We've got a couple of details of some support services there if you do need that. Thanks. Ben's going to hand over to Ben now to go through the National Redress Scheme information.
Thanks, Rachel. So the National Redress Scheme was something that was established as a recommendation following the Royal Commission into Institutional Responses to Child Sexual Abuse. And as a scheme, it commenced on the 1st of July 2018 to run for 10 years. And so applications can be submitted up until the 30th of June 2027. Now, this scheme as a recommendation, the Royal Commission really looked into institutions where sexual abuse occurred with children. And so where people can apply for the redress scheme, where this criteria in front of you applies. So where there has been an experience of sexual abuse, and also they do consider related non-sexual abuse at those same institutions, such as physical abuse and psychological abuse as examples. And that abuse must have happened when the survivor was under the age of 18. The abuse must have occurred before the 1st of July 2018. In order for people to apply, they do need to be an Australian citizen or a permanent resident. And you can only apply if you haven't received a court-ordered payment. So that's an important eligibility criteria as well. And the institutions, in order to apply, the institution has to be responsible for bringing the person into contact with the abuser, and very importantly, the institution needs to have formally joined the redress scheme. And so in some cases, there will be institutions that haven't joined the redress scheme, and unfortunately that does have consequences on people who experience abuse at those institutions, because unfortunately that means that at that point in time there's no one who's accepting responsibility to pay for the redress, and we will talk a little bit later about some of those other issues as well. And the last criteria that who can apply is where, so the applicant needs to be born before the 30th of June 2010. Now, as we're moving towards the end of the scheme at the 30th of June 2027, there's certainly going to be more young people apply, and it's important to know that they can apply as long as they turn 18 before the 30th of June 2028. And some of these other criteria are very important as well. So the abuse must have occurred before the 1st of July 2018. And that date, the 1st of July 2018, is the commencement of the redress scheme. So it must have happened before the redress scheme started. And as long as there's 17 years and 8 months of time of application, it can be processed as though they are 18 years old effectively. So where someone does apply before they're 17 years and 8 months old, then the redress scheme will do a preliminary assessment, and they may do some work in terms of the information requested at the institution, and the applicant, so the person who's under the age of 17 years and 8 months, will be notified in terms of what's happened with that preliminary assessment, but their application won't be fully processed until they're considered an adult, or until the date when the scheme begins processing them right towards the end. Now, that means that as part of that, if someone applies and they are a young person within this categorization, a formal offer cannot be made until after they're 18 years of age. So that's certainly something that's important to keep in mind as well. Now, what is the redress scheme? What is on offer? So the redress scheme is all about recognition and acknowledgement. And in doing that, there's 3 components of a redress scheme offer. Now, the first of those is a monetary recognition payment, and that can be up to $150,000. And people are awarded this recognition payment based on the type of abuse that they experience and the severity of what they experienced as well. So people will receive different payments, and $150,000 is the absolute maximum. Now, a very important distinction to make about this payment is that it is a recognition payment and not compensation. So recognition being that these institutions have done something wrong and that the person experienced harm when they were a child, and it's very different from something called compensation, which we will talk about a little bit later. But compensation being something that people may receive from doing a civil claim. And that distinction, as I mentioned, we'll talk about a bit later. So that's one of the components of the redress scheme. The second component is in relation to counselling, and counselling is something that can be accessed on an ongoing basis. So there is a couple of different ways that takes form. For some people, there may not be counselling services in the area in which they're based, in which case the redress scheme will make a payment of $5,000 for that person to be able to facilitate access to their own counselling. But in areas where the redress scheme and its support services have coverage, they do offer access to counselling, and that can be an ongoing arrangement where sessions can can sort of take place over, initially it's about 20 sessions, and from that point onwards, after those sessions have been experienced, then there can be further sessions requested. Now that's the second component.
So just with that, there's an interesting part of counselling in Queensland, which is that family members are also offered counselling if they have a redress outcome. So they get up to 10 counselling sessions free. That's brokered by a Queensland government department. So I just thought it was worth putting that on the table, because that's something that is actually different in Queensland to other states and territories.
Thanks, Rachel. That's a really good point, and that's certainly in Queensland a very big benefit for people component. Now, the last component of the National Redress Scheme is the direct personal response. So that is an apology, essentially, from the institution to acknowledge what they did wrong and the harm that was experienced by the survivor. And that direct personal response experience is something that takes many different shapes. So for some people, that could be a phone call or a face-to-face meeting with a representative from the institution. For other people, they might request that a tree be planted at the institution where they experienced the abuse, or a plaque be placed on the wall, or a plaque be removed acknowledging a perpetrator's contributions, so there's many different forms that this direct personal response takes, but it is a key component of the redress scheme because it's all about the recognition and acknowledgement, and the direct personal response is meant to provide survivors with that personalised touch and the understanding that the institution has caused them harm, and an apology for what they've done to them. Now, the redress application process, it does involve filling out a form initially, and that form can be done via a paper application form, which can be downloaded on the website of the National Redress Scheme and then sent to Canberra, where the National Redress Scheme are based, or a MyGov form can be completed as well. And with those forms, they are broken into 3 parts. So the first part is primarily administrative, with details about a survivor's name, date of birth, address, contact preferences. The second part involves detailing what the survivor experienced at the institution. So who the institution is, where it was, who was involved, and what happened. And so this part really requires a survivor to tell their story around what they experienced. And that leads into the third part of the form, which is about the impact on a survivor's life. And that section is also requires a survivor to tell their story around how this abuse has impacted their life. And it, obviously, filling out this form is can be incredibly difficult and traumatic. And we'll talk a little bit later about how No More does support clients to fill out these forms and provide them with a safe space, and the adequate support so that they feel safe whilst they're going through this process. So once the form has been completed, it is submitted, either posted into Canberra or submitted via MyGov, at which point the redress scheme do an initial acknowledgement call once they've received and acknowledged the application, and that acknowledgement call is to confirm that the contact preferences of the applicant, to make sure that when they do need to reach them, that they'll be able to talk to them, or that this application belongs to this person. And you can only apply once to the redress scheme, so that's another important thing that the redress scheme does check. And so that once they've spoken to an applicant and confirmed their identity, then the application will progress to stage 2, which is the information gathering stage, which is reflected on this slide by records and review. And what's involved there is the scheme will reach out to the institutions named in the application, and they will request any information in relation to the experience disclosed by the applicant. So whether or not there's any records of their attendance at a particular school or a particular home, whether or not there's any records of named perpetrators in an application, and whether or not they worked at that institution. All of those sorts of things are examples of what the redress scheme is seeking records for, and they're doing that as part of the eligibility requirement to look into the reasonable likelihood of what this applicant's experience was, and that's the evidentiary burden that they apply when they're looking at people's applications, whether or not it was reasonably likely that this occurred. Now, with the next stage, once the scheme has enough information, they then look at moving it to stage 3, where it goes to an independent decision maker, and they're the ones who make a decision about a applicant's case. Excuse me. So when it moves to stage 3, that can take months for an independent decision maker to look at a case. And once they've made a decision, there will be an outcome. And if someone is successful, then they will receive an outcome with an offer, including those things that I described before. When someone does receive an offer, they can ask for a review if they would like that decision to be reviewed. And yeah, sorry, excuse me. It's that time of year, isn't it? So at that end stage of the process, where an outcome's been delivered, the applicants can accept it, or if they're unhappy with it, they can ask for a review, and there are other options available as well. And that is part of the process. Now, moving on, I'd like to pass this back to Rachel to talk about some of the recent changes made to the redress scheme.
Thanks, Ben. So we're in year 7 of the redress scheme now. There was a second year review done. So back in 2020, there was a review done, and there was a final report delivered in 2021. It's only been in April this year that we've actually seen legislative change in response to some of the recommendations that the Australian government accepted. So it's been a slow process, and there's been several other sort of review processes of the scheme. I guess we wanted to check in today to talk about how the scheme is going. I think probably a lot of people know the information that Ben has just delivered, but yeah, we're wanting to talk about how things are looking towards the back end of this. So we've only got a few years left of the scheme. So the new legislation came into effect in April, and it doesn't cover all of the recommendations, but it does cover some. So we're going to go through that today because they are quite significant. So the first one, and this is a really major one that No More's been advocating for many years, and that is that survivors in jail are now able to apply for redress. So prior to these amendments, people in jail couldn't apply unless there were exceptional circumstances. Those exceptional circumstances were if the person was going to be in jail past the life of the redress scheme, or if they were had a terminal illness and were going to die before the end of the redress scheme. So a lot of that excluded a lot of people, and there's certainly that was not envisaged by the Royal Commission. The Royal Commission found that people in jail were more likely to have experienced child sexual abuse, and that people in jail should be allowed to apply. So it's taken until year 7 for this to be changed, so that people who are in prison are able to apply now, which is a great, change that has been made. But there are some ramifications to that. It came into place in April 2024. Certainly at No More, we've seen we've seen a big change in. We've seen a real increase in requests from prisoners for advice, and we've seen a big request for assistance with other support services that I'll talk about later. So while this is a welcome change, we really feel that there needs to be some more work done by government to provide resourcing to actually provide the advice to people in jail, but also to support them. Jails aren't the safest places. They're not trauma-informed places, and you know, we're certainly continuing to advocate that Australian government puts measures in place that will allow people in jail to apply, but to apply safely, and we'll continue to work on that at No More. So the next big change is the changes to process for survivors with serious criminal convictions. Serious criminal convictions is defined as any head sentence, any conviction where there is a head sentence of 5+ years. So prior to these amendments, all people with serious criminal convictions had to undergo a special assessment process before their application, their substantive application could be looked at. The process was that a separate form which needs to detail the convictions, any background around that offending, and any rehabilitation that the prisoner has undergone. That form was sent to the Attorney General of the state and the territory where they live, and also the state and the territory where the offence took place. The AG then looks at whether, if this person was allowed to apply for redress, would that bring the scheme into disrepute, or would it adversely affect public confidence in the scheme? So that process was applied to anyone with that head sentence of 5+ years. What we were finding was that people who had convictions for child sex offences were generally not getting through. People who had convictions for murder, manslaughter, really serious violence were sometimes getting through. It really would depend on the extent of the rehabilitation that they'd done and their re-entry into society. So these changes have been enacted not to the extent that No More has advocated. We have always advocated that everyone should be allowed to apply, regardless of whether they have a criminal conviction, regardless of how long that criminal conviction is. However, we have a change that states that it limits the special assessment process to survivors who've received the 5+ years jail sentence for particular offences, being an unlawful killing offence, a sexual offence, or a terrorism offence. All people who have got a serious criminal conviction, so that 5+ years, still have to apply, still have to fill in the form. The redress scheme then has a look at that, assesses whether it falls into those categories of offences. If it does, then they send that off to the Attorney General's department, the relevant Attorney Generals, for assessment with the process, and it goes from there. I guess the practical effect of this change is that people whose convictions fall outside of this won't have to go through that assessment process, which means it's quicker for them. So that's the main the main change in a practical way. We're finding that people, it also allows us at Know More to give more, more advice that is clearer for people, rather than having to say, well, if you've got a 5+ year offence conviction, it goes off and we hope that it'll get through. But we're able to now advise with more detail that people with certainly, say, drug offences or property offences are really unlikely to have to undergo the process and are likely to be able to access the scheme, which is a good thing. So, yep. Okay, so there's another change to the review process. So Ben took you through the review process before. If someone gets an outcome and they don't like that outcome, then they can ask for it to be looked at by a different independent decision maker. Prior to the changes in April, there could be no new information given to that second independent decision maker. There were limited circumstances that new information could be looked at in what's called a revocation process, but that review process, if there was further information such as information about the type of abuse that they had experienced, that couldn't form part of the review. So these changes allow survivors to provide that new information with their review application. It also allows the redress scheme themselves to request new information as part of that review process. And it does provide some protection against a redress payment being reduced as a result of the review. That last point there is important, because prior to these changes, the messaging that the redress scheme would give is that here is your outcome. You have 3 options here. You can accept it, you can reject it, you can say no, or you can seek a review. But if you get less in that second review, then we can't do anything about that. So I have had many clients over the years who have said, that's a threat that they're hanging over my head. They're saying, we might give you less on a review, and they're trying to dissuade me from seeking a review. So this is a welcome change. It's a policy change rather than a legislative change. And so we're currently working with the scheme to get some clear guidance on how this will work. But the intention is that if somebody gets less on a review, they can reject that and go back to their first offer, which means that people will feel more empowered to actually request the review and then make a decision. I guess what we find is that a lot of reviews do result in the higher amounts, particularly where we can give further information. So that we still have to see how that is going to play out in practice, but it's another welcome change. And then finally, there is the ability for certain finalised applications to be reassessed. This doesn't come into effect until either late September or early October this year. And this is going to apply where someone has made an application and they have got an outcome and accepted. Where someone has had more than one institution in their application and one of those institutions hadn't joined the scheme, it's likely that their outcome would have, their monetary amount would have been less because there wasn't an institution able to pay the portion that was relevant to the abuse in a certain institution. So just as an example, someone may have been abused at a Catholic church that has joined the scheme, and then they also put in their application about abuse that happened, say, at a youth club that hadn't joined the scheme. If they proceeded with the youth club as part of their application, and remembering that people can only make one application to the scheme, so people want to put all of their abuse in to give themselves the best chance of getting the best outcome. So if that youth club hadn't joined and their application was finalised, it's very likely that that would have only got a half of the monetary amount, because the half that was that the youth club was responsible for couldn't pay it, and because they hadn't joined. So this change allows people to go back to the scheme where that non-participating institution has subsequently joined and have it reassessed. So there's a couple of ways that might happen. The youth club, if we use that example, might have found, might have been able to join, and they've joined of their own volition. They may be defunct, so they may not exist anymore, but there is provision in the Act for government to take responsibility for defunct institutions. So governments can actually be the funder of last resort for defunct institutions, or the youth club may have not been able to join for financial reasons, but there is still the possibility for government to take responsibility as a funder of last resort for still operating but unable to participate institutions. Unfortunately, that last category, we've seen only one institution having been taken on by government, and we're still advocating for government to take responsibility for a lot more defunct and unable to join institutions. But this will be useful for a couple of people, for many people who went through the process, particularly early on in the scheme, where they were not willing to wait for a non-participating institution to join. So that's that last one. I'm going to hand back over to Ben to talk about some issues that are enduring that we need to know about still.
Thanks, Rachel. So some really important issues to note in relation to the redress scheme include the fact that whilst people can apply to the redress scheme for free, it's something that they can do freely. There's no cost to apply. There is a cost in the sense that if someone is eligible and they're given an offer, they do have to sign a document to accept that offer. And that document releases the institutions, responsible institutions, from any future civil liability. And that can be a really huge cost for people to apply, because that's something where if they do a civil claim, it may result in a much better financial outcome. And so we will talk a little bit later about how we do assist clients to connect with civil lawyers to receive advice about their civil options because of this deed of release, because it's a very final thing applying for the redress scheme. Now, assigning a deed of release to accept redress does release the institution from future liability, but it doesn't release a perpetrator from liability. So if a perpetrator is still alive, then someone may be able to look into receiving advice about whether or not they could pursue a civil claim against that person or criminal consequences as well. So that's something important to note. Now, where there has been, someone does apply for the redress scheme and they have already done a civil claim against the institution, then this will be considered a relevant prior payment, and it's deducted from any offer that the person receives from a national redress scheme. And when this is done, they do apply interest to every year since that person's received that payment up until the year that they do apply for the redress scheme. And so where someone has received a substantial civil payment it can sometimes mean that that person, if they apply for the redress scheme, they may not receive a monetary recognition payment, but they would still be eligible for the counselling and the direct personal response. But it's really important to note that I guess the redress scheme does look at those civil settlements, and those are deducted. Now, one of the last things that's come about as a change of one of the reviews in the redress scheme is the advance payment of $10,000. And applicants are eligible for this as assessed by the redress scheme. So it's something that people can't ask for or request generally, but where someone identifies as Aboriginal or Torres Strait Islander and they're over the age of 55, then they may be eligible to receive an advance payment of $10,000. Where otherwise, if someone applies and they're over the age of 70, then they may be eligible to receive an advance payment of $10,000. And also another example of that might be where someone is suffering from a terminal illness, they may be eligible too. Now, the scheme does look at the preliminary eligibility of applicants when they're assessing this. So it's not something that's automatic for people if they fall into the criteria that I've just described. So it's very much something that the redress scheme have a discretion with this payment, but it's certainly something that's important to note. And the consequences of accepting this payment mean that if someone is found eligible for the redress scheme and given an offer, they would receive $10,000 less in their final payment because they've received an earlier advance payment. Now, so for example, if someone was found eligible for $100,000 and they received a $10,000 advance payment early in the process, then their final payment, if they accepted it, would be $90,000. Now, if someone is not found eligible for the redress scheme, but they accept an advance payment, with that, they do not have to repay the $10,000 in most cases. So they don't have to repay that $10,000. And this is something that does happen for some people where they may be fall into this criteria and receive $10,000 but are ultimately not found eligible for the scheme. And fortunately, in those cases, they do not have to repay that. So the only cases where people do have to repay the $10,000 is if someone is eligible and they receive an offer and they don't accept that offer, or they withdraw their application before they receive an offer, in which case that $10,000 does need to be repaid. And we'll talk a little bit later about how No More has financial counsellors who provide fantastic assistance and advice with this, but it's certainly an important feature of the redress scheme currently. Now, I just wanted to highlight some of the recent scheme data. So certainly you can all see these numbers in front of us, and there's been a substantial amount of applications made, and of that, close to half of them have been resolved with outcomes. And from that, there's been payments totaling $1.4 billion. So from that, obviously there's a lot of cases, a lot of applications yet to be decided. And with the redress scheme, it does take time for these applications to be processed. It is at the current time taking about 12 to 18 months. It can be quicker for some people, and it can take longer for others, because everyone's application is different. Everyone's story is different. Some people have institutions in their applications. Other people might just have one institution. And as I highlighted before, with the waiting time, the redress scheme does go request information from institutions, and sometimes that information can be more difficult to obtain from institutions than others, in which case the process does take longer. But on average, 12 to 18 months is what we're seeing applications being processed in currently. And I'd just like to mention too, that the redress scheme can process some priority applications quicker, with like terminal clients who are experiencing terminal illness, for example, or it might. So the thing that I wanted to talk about now is in relation to some of the other legal options that we advise on. So the redress scheme is one option, but there are other options for people. And as I mentioned earlier, a civil law or common law claim is an option that is available to clients, and all clients should talk to a civil lawyer to receive this advice, because that's something that we aren't civil lawyers, and so in terms of clients receiving this advice and applicants receiving this advice, we strongly recommend and encourage them and help them to connect with civil lawyers to receive this advice. Because as I mentioned before with the redress scheme, if you do accept an offer, the deed of release means that you cannot bring any future civil claims against that institution. Now, with a maximum payment of $150,000 for the redress scheme, sometimes for some people, a civil claim may result in a substantially higher payment. And the only way for that person to find out is to talk to a civil lawyer, to receive advice, and then pursue a claim against that institution. And that's something that is certainly an option for people that we encourage and commonly assist people to connect with civil lawyers via warm referrals. So what we like to assist clients to do is we like to give them advice about all of their options. So including the redress scheme and including the options available to you on the screen. And where clients are seeking that civil advice, we can connect them with law firms throughout the country who have experience with cases against different institutions to receive advice about whether or not a civil claim is an appropriate option for them, or whether or not redress might be a better option, for example. And so that's one example, a civil claim of an alternative to the National Redress Scheme. Now, another alternative to the redress scheme are internal institutional redress schemes. And various institutions, including government-run and faith-based institutions, have redress schemes of their own. And these redress schemes are different from the national redress scheme run by the federal government in Canberra. And so they have different rules about applying, different payments, different criteria, and different eligibility. And so for some people, pursuing a claim through an internal institutional redress scheme may be a much better option. And a third option that we do advise on for people is in relation to victims assist compensation within each different state. So every state in Australia has a different victims assist compensation package, and those packages usually involve payments, a recognition payment to acknowledge the harm that's been done, and also involve financial assistance for people to pay for expenses related to the crime or the trauma that they've experienced. So in Queensland, for instance, there's a scheme to assist people to help pay for expenses such as counselling, for example.
I might just chime in there and say that we do advise quite a few people who were not eligible for the redress scheme because they were not abused in institution, and a big proportion of those people were people who were abused by family members, and unfortunately for them, Victims Assist claim is often the only choice that they have. So we can assist people to make those applications. It's quite complex. There's different rules in each state, so we've got officers everywhere that can help people to do that.
Thanks, Rachel. Yep. And I'm now going to pass on to Rachel.
Okay, thanks. Sorry, thank you, Ben. Just a little bit about NOMA. I'll go through this fairly quickly so we've got time for questions at the end. We're a free, independent community legal service. We give free advice and support to survivors. And like Ben said, we help people understand their compensation options, and we can support some vulnerable clients. We have a multidisciplinary approach. So I'm going to take you through what each of our disciplines do and how we can provide that support. We've got experienced intake workers who speak to people at first to take their details and book them in for an appointment. We also have a triage service that runs in all open hours, where we've got a lawyer and a counsellor or social worker available if someone becomes distressed in that intake process. We also have a legal team, obviously, to give advice. We can talk to them about their options. We give referrals to civil lawyers. And for particularly vulnerable survivors, we can actually help them with filling in their redress applications and getting their application in. We do a lot of work as well in advising people throughout the redress process if there are any hiccups with their application, and also at that offer stage about their offer, and increasingly a lot of advice about people who are found ineligible for the scheme. We have an Aboriginal engagement team, Aboriginal and Torres Strait Islander engagement people who give cultural safety and support for those communities. They have a really deep knowledge and understanding about the complexity and impacts of trauma on Aboriginal people's families and communities, and they help the rest of No More understand and respect cultural protocols when we're assisting Aboriginal and Torres Strait Islander clients. We have a financial counselling team who are really great in helping people who have either applied or are considering applying to understand the implications of that payment, how to protect the payment when they get it, but they can also do a lot of work before that, so very early on, to give them help with financial hardship support. So they might be able to reduce or get rid of certain debts that a person has, so that when they actually get a redress payment, if that's what they choose to do, they're in a really good financial position, and they are able to make much more informed choices about what they do with their money. We also have a support services team who take a trauma-informed practice approach in supporting people. They can support people in initial advice calls. If we are helping someone in an ongoing way, they'll help people to get through the process. They'll often start to be the primary contact once an application's been lodged and someone is waiting for that quite long period for their application to be decided. So they'll check in regularly to see how someone's travelling. They can also provide referrals to local services that can help people on an ongoing basis, because we're not able to continue that support after their redress claim has been finalised. And finally, I just want to talk about the work that we do for other workers. We provide training and resources. There are a funded group of redress support services throughout the country who are able to help people to fill in applications, give them counselling and support them through the process. So we have a RSS, a Redress Support Services team, who help in a practical sense by giving advice, checking applications, but we've got a really extensive portal for those workers, which has webinars recorded, resources such as fact sheets and manuals and that sort of thing. So redress support services in Queensland. I've got a link at the bottom here, which you'll get these slides to those redress support services. They're throughout Queensland. Like I said, they can support people through the redress process. We work really closely with them. We make a lot of referrals to them. They refer back to us. So the whole redress support, I guess, landscape is, and the support system that we're a part of, work really closely with each other, as well as working closely with the redress scheme. No More itself have got some really great resources on our website. Have a look there. Like, again, there's fact sheets, there's information, there's some webinars and things like that. So encourage people to access those. We've got offices throughout the country in Perth, Darwin, Brisbane, Sydney, Melbourne and Adelaide, and we do outreach when we can to remote and regional areas to talk about redress and to assist people. There's some details of where we are, but this is our 1-800 number. So if you have seen clients who want to get some advice from us, they need to call that number. They'll speak to one of our intake officers, who will then make an appointment for them, and they can start their process from there. So we're slowly running out of time. Didn't realise it was going to take that long. But Penny, are there any questions?
Thanks, Rachel and Ben. That was great. And look, we did start a little late, so let's take a little bit of time for questions. It's all good. Yes, there have been a few come in. The first one comes from Siobhan. What is the reason behind denying the scheme to children who are younger than 8 when the abuse occurred?
It's really about people who, it's about the timing of the start of the scheme, and that someone has to be 18 before the scheme ends. The recognition payment and the redress is for people who are adults now but were abused as children. So it's really just that this scheme is in existence in a point of time, and that unfortunately there is a group of people who are going to miss out, including people who are going to miss out after the scheme closes. So it's not ideal, but it's really just that eligibility and point in time.
Mm-hmm.
Does that answer?
Yeah, that's great. Thanks, Rachel. I think that's just a really difficult reality in this space, isn't it? So, yeah, thank you. That's good to know. The next question comes from Eleanor. She's asked if No More's doing CLEs in prisons since the changes. She said she's a lot of clients who have been signed up with private firms and aren't aware of No More or that there's a free scheme.
Good to know, Eleanor. Very good information. We are in the process of making contacts with prisons to do the CLE. We consider that really the scheme should be going into prisons and spreading the word, but we will be doing that work. We certainly, when we're out on outreach, if there is a prison in the outreach area, we'll go and try and speak to people. It's difficult, we find, to actually find contacts within prisons who want that information, but we're certainly doing our best to spread the word as much as we can. Look, I would say if anyone who's on this webinar has got any information about law firms who are really active in prisons, we also see claims farmers in prisons who go in there and tout for business. Could you contact us at No More and let me know? I'd love to have a conversation just to get a real feel for the landscape about what's happening in prisons, because we recognise that as closed systems, prisons are a place where people are really open to abuse and to the abuse of the system, I guess we're saying. So we want to make sure that people do know that they've got other options available. So please contact me. I'd love to hear from you.
That's great. Thanks, Rachel. And just to say, if people want to email through to me, then I can pass that on to Rachel as well. So is another way of getting through. Thank you. That's really good to know. The next question is again from Siobhan. If a person in prison before 2024 applied and was rejected but did not have the type of crimes listed today, are their applications automatically reviewed, or do they have to, or can they apply again?
Unfortunately, they can't apply again.
Oh, really?
That was that's so if they've been rejected and not allowed to apply on the basis of their serious criminal conviction, then they can't apply again. That's the end of the road for them. I would say that even with these the three offences that I talked about, they still have the option and the discretion to make someone go through that special assessment process if someone is if there are exceptional circumstances. We're not quite sure what that looks like, but I think it probably is if you Google someone and they're very notorious for their crimes and they don't fall within those categories, there's a chance that those people may need to go through. But it's something that we've certainly raised in our advocacy about this, but no, they can't revisit their application and their serious criminal conviction.
Okay. So that's, I suppose, a segue to a question that had sort of come through the registration process rather from the live session, just about the other supports or financial assistance for people who are ineligible for the scheme, whether that's prisoners or others.
So certainly where prisoners are ineligible, we always, we will talk to them about getting civil advice, because they may well have that that claim available where their criminal conviction wouldn't be such have such an impact. Unfortunately, I've seen civil advice that people have been given where if they've been in jail, in and out of jail their whole life, then the civil lawyer will often say, yes, you may have you've got a claim, but your economic loss is not that great because you have been in and out of jail your whole life, which doesn't always make sense, given that often it's the abuse that has led to the offending and led to the incarceration and that vicious cycle. So civil advice is one thing. Like I said before, the victims of crime application, schemes might be an option, but they're limited in terms of the amount of money that people can get from them. They're also limited in terms of timing. So in Queensland, for instance, anyone abused before 1969, there's just not a scheme available. And then prior to 2000, between 69 and 2009, there's some pretty strict reporting and conviction criteria that apply. I won't go into those, but it is an option, but not the best option. And then I guess that's about the only options that people have. I know that the Australian Law Reform Commission are doing a review into sexual violence, the sexual violence system, legal system, and we've certainly talked to them about the possibilities of compensation for people who are ineligible for the redress scheme. But for instance, a redress scheme for people who are abused within their families is not something that's likely to get up. So I guess there are options, but they're limited is what I would say.
Great. Okay. All right. That's really helpful to know. Thanks, Rachel. A couple more comments, questions have come through. So Eleanor has followed up around the answer on the prisons questions. She said, when clients are filling out the section of the application about the impacts on their life, do you recommend they have evidence such as psych counselling or medical reports, etc., if they can afford it or if it's possible?
Yeah. So the part about the impact, like Ben said at the start, it's assessed according to the type of abuse. So the impact itself, there's an assumption that everyone who has been abused is impacted. And the amount that's allocated within the matrix is $20,000 for impact. So someone will get that $20,000 whether they tick one box, because you either have the option of ticking boxes in the application form or putting more statements in. So if someone ticks one box, they're going to get that $20,000. If someone puts in a whole lot more information, including psych reports and all that sort of thing, they're still only going to get $20,000. So it's not necessary. People don't need the evidence of the impact. A lot of people just choose to tick their boxes, and that means that if they are eligible overall, they will get that portion. It's not like a civil claim where you have to show the extent of the injury that has happened. It's really just has there been an impact? If yes, you get that portion of the payment.
Okay, great. I think that's super helpful to know. Thanks, Rachel. So the next question is a little bit more strategic. So it comes from Alicia. She said, will No More be advocating to extend the scheme beyond the current end date?
Oh, that's a good one. There's talk about that. That's a strategic decision that No More hasn't made yet, I guess is what I would say. I would say that the process that would be involved in doing that would be massive. There would need to be negotiations between the Commonwealth, states and territories. Institutions would have their say in this. I think it's a possibility, but we are yet to take a final sort of policy position on that.
Okay, great, excellent. This is a segue, I guess it sort of is relevant as well, that could you just talk a little bit about the higher level advocacy that No More does do? So, you know, where are the forums that you're making the case about these things?
We do submissions to a number of inquiries and in response to draft legislation on a wide variety of topics, but the main ones that we've contributed to was the 2-year review that happened. Robin Cook ran that, and we made several submissions to that, as well as speaking to the reviewer. The other one is the Joint Select Committee, which is set up for monitoring and the implementation of the redress scheme. We have written probably about 5 submissions to them, appeared before that Joint Select Committee 3 times. We're due to appear again on the 2nd of August, where we'll be talking about the gaps between what has been put into place with these amended legislation and what was actually recommended by the 2-year review. So we have a lot of contact with the Joint Select Committee people. We speak to politicians in Canberra about changes that we want to see. We put our advocacy up on social media, and we do everything that we can. We have a law reform and advocacy team. We're really lucky that we've got that team, and we'll certainly put a lot of effort into making sure that we're putting the views of survivors before the relevant inquiries, because that's what it comes down to. We think we've spoken to 18,000 people since the start of the scheme, and we really centre survivors' voices in our advocacy.
Fantastic, excellent. Thank you so much. And I know sort of personally what great work No More does in that space. So thank you for all that you do. Siobhan said that she'd be interested in separate training on how No More runs intake and triage someday, just as a comment. And then
please contact me, Siobhan.
Yeah, no worries. You can do that through me as well, Siobhan. And then Alicia has said, in terms of the prisons question, NAJA in the NT, which is the Aboriginal Legal Aid Service, is the relevant party, and also has said a big thank you for the wonderful and trauma-informed work you do, and for the great presentation. So that brings us to the end of the questions, Rachel and Ben. So thank you very much, and thank you to all our attendees for staying online for that bit of extra time while we worked through that. So that's it for today. Thank you so much for a fantastic and really informative presentation. I think it's been just excellent and a great refresher for everyone. Before we go, just a reminder, to please complete the feedback survey that'll pop up on your screen once the webinar closes. It does really help us to continually improve our webinar program. That'll be it from me. We hope to see you at the next CLCQ webinar. So thanks everyone. Bye for now.
Bye.
Thank you. Bye.